Well, welcome all. It's about 1 minute after 1 o'clock East Coast time. Thank you all for joining us today. Before we dive in, I want to mention a few quick items about logistics. First, on your screen, there should be some icons. The resource icon includes a copy of the presentation. If you'd like, you can use it to download the deck to your desktop or print it out and take notes. You'll also receive a linked copy via email after we're done. Second, you will see a QA feature. You can use it to ask questions along the way, which we'll try to get to either during the presentation or at the end. Feel free to reach out, of course, to Brian or me directly afterwards if we don't get to any particular question you raise. Third, please note that the presentation is being recorded. And finally, towards the end, you will see a QR code that you can use to request CLE credit. If you have any questions about any of that, please feel free to reach out. So first, introductions. My name is Elena Marcus. I am located in the Baltimore office, and I'm chair of the Labor and Employment Department. My co-presenter today is Brian Barger. He's located in our Charlotte office, and he is one of our experts on these issues, so I'm thrilled to be presenting with him. For those of you who don't know or who aren't members of the firm, I know some of you are, McGuireWoods is a full-service firm with lawyers across the country and in London. We are honored to represent some of the top Fortune 500 companies, as well as small local nonprofit companies and everything in between. And we're also honored to have been recognized by BTI for our client service, which is really one of the core values that drives our firm. So you'll see all that up there on the slide. As chair of the Labor and Employment Department, I'm particularly proud of our 65 or so L&E team members across our footprint. Our team and individual members of our team have earned recognition in many publications, including Chambers, BTI, US News Best Lawyers, and Corporate Counsel magazines, Who Represents America's Biggest Companies survey. So before we go further, of course, we have a disclaimer. Because there may be some of you that don't have video up, I will read it. It's also on the screen. This presentation is intended to provide information of general interest to the public with respect to the subject matter covered. It is not intended to offer legal advice about specific situations or problems. McGuireWoods LLP and today's presenters do not intend to create an attorney-client relationship by offering general interest information, and reliance on information in this presentation does not create such a relationship. Due to the numerous factual issues that arise in any employment or government contract-related question, you should engage or consult your attorney if you need legal advice regarding a specific situation or issue. So as I said, we're not providing legal advice, and really nor could we. If you think about it, the members of this audience come from all different places with respect to the issues we're talking about. There's large employers, small employers, public organizations, private organizations. Some folks are in organizations that have sophisticated, long-standing DEI practices. Some haven't focused much on these topics. You're in different industries, you have different risk profiles, you have different risk tolerances. In fact, you're different with respect to the myriad of factors that influence an organization's decisions, generally, and particularly on how best to handle DEI issues. I also want to acknowledge that DEI issues can be really hard topics to talk about. Many people are very invested in these issues, and reasonable people can differ in their views regarding DEI. We're not here to opine about broader public policy issues. Our focus is really on the legal landscape on DEI issues, the weather, as it were. including what's been going on over the past few years and the significant developments during the past 3 weeks or so with the new administration. Because that is what you need to be familiar with, I think, to both spot the issues and help guide your organizations through these issues. So what are we going to do? We're going to talk about what's been happening in the courts regarding DEI. We're going to talk about what's been the key focus of plaintiff demands and claims on DEI. We're going to talk about what's new regarding agency enforcement focus. That's a big one. Brian can't wait to talk to you about that. And then lastly, we'll talk a little bit about what's keeping us and probably you up at night. So we've got a birthday candle here, a cake with a 1 birthday candle. Why is that? Well, it's because we're about 1.5 years after the decision, probably the most significant decision in the recent past on these issues, which is the Students for Fair Admissions versus UNC and Harvard Supreme Court case that was decided in June 2023. It got a lot of press. We all heard about it, much of which I think was very imprecise. So we'll just talk a little bit about it to put it in perspective. Based on Supreme Court precedent, both schools, UNC and Harvard, had admission processes that explicitly factored race into the decision. The Supreme Court held that the use of race as a factor in the admissions process could not withstand strict scrutiny required by the Equal Protection Clause and was therefore unconstitutional. So we say in that first bullet that colleges may not consider race as a standalone factor when selecting students for admission. That is what the court held. The reason we use standalone is the court went to pains to comment that nothing prohibits universities from considering an applicant's discussion of how race affected the applicant's life, so long as that discussion is concretely tied to a quality of character or unique ability that the particular applicant can contribute to the university. And one of the most often quoted, I would say, sentences from the decision is this: eliminating racial discrimination means eliminating all of it. And you see in many, many of the cases and letters and requests for investigations and things like that that have followed that decision, that sentence is quoted over and over again. It's definitely, the decision has sparked increased scrutiny of DEI practices everywhere. A couple things I want to point out, which I think you will see is a recurring theme in this discussion. One is that there wasn't an individual plaintiff. Rather, you had a nonprofit organization, Students for Fair Admission, which describes its purpose as to defend human and civil rights secured by law, including the right of individuals to equal protection of the law. Second, I think this decision points out that DEI policies and programs are being challenged on numerous different bases. The decision in this case was based on the Equal Protection Clause of the 14th Amendment. The court makes the point of saying that the decision would have been the same, or said another way, that the practice of using race as a factor in the admissions decision would also have violated Title VI of the Civil Rights Act of 1964. And where this gets really close to employment matters is that Title VI of the Civil Rights Act of 1964 is, as the court described it, essentially identical to Title VII of the Civil Rights Act of 1964, which of course is the law that, one of the laws that we focus on a lot in the employment world. So I commented that I was frustrated, I guess, with some of the way the Students for Fair Admissions decision was widely discussed. And this is where that comes in. Obviously, the decision had a significant impact on college admissions. But there were a lot of people talking about how it was a major change in the law affecting employment. It was not. I mean, the underlying laws that were discussed in that case and all these other cases, the Constitution, for one, Section 1981 of the Civil Rights Act of 1866, and Title 6 and 7 of the Civil Rights Act, well, more Title 7 of the Civil Rights Act of 1964, which are the provisions, they haven't changed. And Title 7, as we say there in employment, makes it illegal to factor race, sex, or the other protected categories, color, national origin, or religion, into any employment decision. It also makes it illegal to segregate or classify employees or applicants based on any of those protected categories. That was true before Students for Fair Admission, and it remains true today. And the case law is very clear under Title VII that means that race or sex or any of the other protected categories cannot be a negative factor. It also cannot be a positive factor. There can be no preference. There can be no plus factor. None of that has changed. Similarly, Section 1981 prohibits race discrimination in the making and enforcing of contracts. That also has not changed. And in the employment world, it's well understood that the employment relationship is one such contract. What has changed recently and since Students for Fair Admission is this. I mean, we and most of you on this call have probably primarily been focused on DEI issues in the employment context, and particularly in the hiring and firing and terms and conditions of employment. But these same legal challenges and constitutional discussions are happening in much broader contexts. There are now broad challenges to employer DEI programs, as I mentioned before, often by nonprofit organizations, based on published policies and program provisions, including statements on websites and in SEC filings about their racial and gender diversity goals that are often now argued to be admissions of intentional discrimination or illegal quotas. There are challenges to diversity grants and scholarships in education and elsewhere. State legislatures have been targeting diversity programs in state agencies and schools, and even trying to attack training done in private corporations, though with less than great success on that. Generally, there has just been renewed attention to selection processes writ large for services and rights and benefits where they are open and available, or available, I guess, exclusively to members of some races and not others, or where race is a plus factor. We'll talk about a few examples. So one example in the private context comes from, American Alliance for Equal Rights versus Fearless Fund Management, which was a case that went up to the 11th Circuit in 2023. Fearless Fund is a venture capital fund that invests in women of color-led businesses. And their mission is to bridge the gap in venture capital funding for women of color. The private organization, it ran the Fearless Strivers Grant Contest. It was open only to Black women and offered women $20,000 apiece and digital tools to assist them with business growth and mentorship. The American Alliance for Equal Rights is a membership organization that's dedicated to ending racial classifications and racial preferences in America. It challenged Fearless Fund's grant contest on the grounds that it violated Section 1981's prohibition on racial discrimination in contracting. Fearless Fund made numerous arguments in defense of its grant program. It argued that there was no contract and thus 1981 didn't apply. It argued that it was a permitted remedial program. And it argued that the contest terms were protected by the fund's right to freedom of speech and expression under the First Amendment. The district court agreed that they may have a decent argument. The case and the denial of an injunction was immediately appealed to the 11th Circuit, and the 11th Circuit disagreed with Fearless Fund's various arguments in support of their program. It explained that there is a distinction between advocating race discrimination and practicing it, or between words and expressions and actions. The former are protected under the First Amendment, the latter are not. And it has a long discussion of sort of the distinction between words and actions, which ends with the quote that we have on that slide, which is Fearless's position that the First Amendment protects a similarly categorized race-based exclusion risks sowing the seeds of the anti-discrimination law's demise. It's a pretty strong statement. Ultimately, that case was before the court on American Alliance's request for a preliminary injunction against the program. The appellate court said the injunction should be granted, and the case settled. So that was the private context. Next, we'll talk about the public context, or the government context, and a case called Ultima Services versus the U.S. Department of Agriculture. This involved a U.S. Small Business Administration program that awards contracts to businesses that are 51% owned by socially and economically disadvantaged individuals. So far, so good. And though the program was open to individuals of all races, the SBA used a rebuttable presumption that individuals in certain racial groups were, including Blacks and Hispanics and other minorities, were socially and economically disadvantaged. Ultima was a business owned by a white woman, and she challenged that rebuttable presumption as violating the Equal Protection Clause. The court agreed and held that the SBA's use of a rebuttable presumption violates Ultima's Fifth Amendment right to equal protection of the law. It enjoined the SBA from using the rebuttable presumption of social disadvantage and administering the program. And so what happened? Well, the SBA made significant revisions to its selection process after that. We did a legal alert on that. In a previous slide, there was a reference to another case, Nazard versus the Minority Business Development Agency. Very, very similar case. It was a Department of Commerce program that provided assistance to socially or economically disadvantaged individuals. Again, there was a presumption involved, and the court said, no, you can't use a race-based presumption, and doing so was unconstitutional. And with that, I think I'm going to turn this over to Brian, who's going to pick it up there.
Yeah, thank you, Elena. Good afternoon, everybody. Good morning, depending on where you are. As Elena noted, the underlying laws that we're talking about, Title VII, Section 1981, certain provisions of the Constitution, they're not new, right? But it's the level of scrutiny that's applied to DE&I based on those laws that definitely is somewhat new. And it's been picking up speed, frankly, not just under the current administration, but in the years prior to that. On my end of things, given what I do on the labor employment team, ironically, I've been spending a lot of time trying to think about and act like, what if I was a plaintiff's lawyer? Which is a terrifying thing, since I'm not. But it's a good exercise for you to do as well, right? Because if you think about what's going on in this space, if you want a flavor, frankly, for what's coming ahead here in 2025 and beyond, all you really need to do, in my opinion, is to look back over the last 5 years. And so if you're not inclined to sort of think like a plaintiff's lawyer, we're going to pretend to be one here for a second and talk to you a little bit about what we're seeing and where we're seeing it. So let's start with the plaintiffs groups themselves. If you actually look at the anti-DE&I space of late, and again, I'm talking really the last 5 years in particular, there are a handful of plaintiffs groups out there that have been very active in this space. They all have websites. They all have PR rooms. They're all very vocal about what they're doing and how they're doing it. And you can look for yourself. The two main ones, frankly, are America's First Legal and the American Alliance for Equal Rights. America's First Legal is the group that's led by Stephen Miller. American Alliance for Legal Rights is the group that's led by Edward Bloom. But there are a handful of other ones across the country, some of which happen to be focused on particular subspaces like in education or in healthcare. But they operate along the same lines. The reason I call them out is, like I said, first off, I mean, you can go online and see what they're saying. They will post their demands. They will post their claims. They'll post their complaints. They'll talk about victories. They'll talk about losses. It's interesting to see what they focus on and what they don't. The other thing that I think is really important for people to understand, when it comes to America's First Legal in particular, Stephen Miller is now the Deputy Chief of Staff for Policy in the Trump administration, right? That's important, right? Why? Why do you ask? Well, if you want to try and think about what the administration is going to focus on, from an agency enforcement perspective, which we're going to get to in a little bit, we would be foolish to think that Mr. Miller didn't have the president's ear on that, and that the tactics, frankly, that the America's First Legal has been engaged in over the last 5 years, and groups like them, aren't going to be flowed down into agency action very shortly. So I think it's a good place to start. It's not the only place to start. Frankly, they make it easy for you. They've got a new anti-DE&I landing page, no less, right, that you can go to that sort of consolidates a lot of this. But you can look around on your own and see what you find. So what jumps out when you do, if you actually peruse the websites, you look at the complaints, you think about the actions that have been brought over the last 5 years, there are thematic issues. And what I would say, again, I'm trying to put myself in the mindset of a plaintiff's lawyer. They're not stupid. They are looking for particular items and particular actions that, in my mind, are sort of low-hanging fruit. And what I mean by that is, I do a lot of affirmative action work. I do a lot of D&I work. We do a lot of statistical analyses and class action work related to challenges to sort of holistic sort of programs and hiring and firing and promotion activity. And a lot of that's driven by statistics and complicated legal rules about something called disparate impact. It's very complex. They're not complex. When you look at these suits, they're not bringing disparate impact claims. They're not spending hours and hours roaming through statistics, doing detailed discovery into analytics on people's compensation practices and hiring numbers and other things like that. They're not doing that. They are doing what I would consider to be sort of just high test, straight up, old time fashioned disparate treatment claims. Meaning you're treating me differently than you're treating Elena based on our race, sex, national origin, age, etc. They're looking at straight up disparate treatment. And so what are they looking for? They are really focusing on 6 particular items. Corporate U.S.-wide employee diversity goals with short time periods. You might ask yourself, why is that? Goals are not illegal. And if you think about any goal, right, metrics that you set, really a goal at its highest and best use, whether it's tied to DE&I or other things, it's a mechanism to be self-reflective. And in fact, as a federal contractor, until recently, you're required to set goals, for example, for minority and women hiring in placement. And you're supposed to look at sort of what you've been doing, what your workforce looks like now, and opportunities for outreach and pipeline engagement in the future. That's what a goal is. But the law has always been, at least on the employment side, goals cannot be turned into quotas. And what's the difference? Well, a goal is aspirational. I look at myself, I look at who I might think I could be in the future, and I try and take positive actions to sort of rectify that, like targeted outreach to make sure that I'm getting a good top pipeline of applicants, looking at my internal and external programming and policies to make sure there are not artificial barriers that are creating disparities in how I go about selection, making sure people are trained properly. All those things, perfectly fine, perfectly legal. What turns a goal into a quota, though, is when you have programming and actions that either implicitly or explicitly make race, sex, national origin, etc., a factor in selection. So you can cast the net broadly, but when you reach into the net and you pick a fish based off of race, sex, national origin, etc., that's a problem. And so they're trying to look at goals that have very short time frames where they can go back and say, that's a really aggressive goal. We think it's almost impossible, in fact, for you to meet that goal unless you're putting your hand to the neck and picking a particular fish. How are you going to do that? So that's one thing they're looking at. Very aggressive goals with very short time frames. And they're also looking at things that are a lot closer to selection. And the most popular one is diverse slate requirements, which in NFL refers to as the Rooney Rule. And that's where you're not making race, sex, national origin, et cetera, a final selection factor for the final hiring decision. But when it comes to interviewing, they say, under this practice, the final interview slate, the final 5 or 6 people who get the final interviews before the hiring managers and others, they have to have at least, for example, 1 person of color and 1 woman, right? What's the problem with that? Well, it's not the ultimate hiring decision, but it's a selection decision. Other people may or may not have been chosen based on those parameters. And that, is arguably an issue under Title VII. There's a lot of litigation about where that line is, but they're looking for that because, again, you're not just casting the net, you're sort of putting your finger into the selection bucket. And arguably, that's sort of an easier target. Likewise, speaking of targets, they're looking at diversity internships and scholarships that have clear set-asides, meaning other individuals can participate, like in the Fearless Fund case, but others cannot, based on race, sex, national origin, et cetera. Frankly, this started under the Obama administration, actually, with a lot of Department of Education action in this space against colleges. It's just taken time, frankly, to trickle down into the private sector. And then they're also sort of looking at other things, exclusive employee development training programs and conferences and things sometimes that grow out of ERGs, frankly, within companies. When those programs, opportunities, networking, mentorships aren't available to others. Likewise, they're looking at supplier diversity programs. Lena gave you a couple of examples of that. And then executive compensation that's tied to DE&I outcomes, right? Some of these things, again, are not expressly illegal, right? Executive comp tied to a DE&I outcome is not illegal per se, right? Which is the problem? The problem is, again, the argument goes, and again, it's just an argument, that when you incentivize people to hit goals and you negatively incentivize them if they don't hit goals, what you're really saying is the goal is not a goal. The goal is really an implicit quota, and you need to hire by the numbers. And what people worry about, I think, in this litigation is even if the company says, no, that's not how we really intended. We've told people that's not what we want to do. On an operational side, sometimes managers, they want to hit their bonus, right? They want to make their money just like everybody else. And even though the company may have had very good guidelines about what to do and what not to do in this space, sometimes operationally managers will turn to their subordinates and say, Elena, I saw that I was on the negative metric last week again. All I know is I don't want to miss my bonus at the end of the year. I don't care how you make it happen. Get me off this report. Is that a quota? Not expressly, but is the message to hire, fire, promote, et cetera, based on race, sex, national origin, et cetera? You bet, that's the message. And so that's what they're really focusing on. They're really looking for easy things. And they're gleaning this, frankly, from the materials, like Elena said, that individuals are sort of self-posting. So here are a couple of examples from back in 2022. One involves sort of a grant program in business accelerators that had limited sort of access to individuals based on race or gender. Again, it was exclusivity. That's the issue. There are a couple of cases too about sort of pipelines and whether or not you're doing more than just sort of spreading the net broadly, but you're actually sort of, again, making selections based off of goals. And again, the argument for some of these things that these goals really are not goals, that they're really implicit quotas in action. And so, for example, in the second matter, you'll see they had a hiring goal, but then they talked about, okay, how do they tactically deal with that goal? They talked about benchmarking and sort of internal reporting that tied to that. And then they talked about sort of the holistic sort of action that related to the program itself. And then they ultimately argue that, by the way, an executive compensation is tied to this. So when you look at the collective swirl around the DE&I, collectively they argue it crossed the line. And that's one thing I would say about, tactically the way things happen in this space. Again, the plaintiffs who do these actions, they're no dummies. And when they bring a claim, and I would encourage you to think the same way they do in this, they don't just focus on one item. In fact, they do something that Elena and I are frankly used to seeing a lot. It's like sexual harassment claims, right? When people bring a sexual harassment claim that's based on a hostile work environment, they don't just sort of call out one or two items. They'll certainly have an item or two that may be worse than others, right? But they'll talk about the comments that people make and the snide remarks that happen down the hall, or the statements that are made during programming, and the people who got passed over by promotion, and the bad commentary that happened with someone's supervisor 2 years ago. And they'll package it all together and try and talk about how holistically it creates this environment that's unlawful. And they do the same thing in these DE&I complaints. And they don't just sort of look at one particular piece of DE&I programming. They try and argue that the holistic effect of the DE&I programming, taken as a whole, create this environment that pushes things from what would otherwise be purely lawful behavior into unlawful behavior. And so here's an example of one that was actually came out of an OFCCP complaint back in 2024. And they pulled things offline, right? These plaintiffs don't spend hours and hours and hours looking for material. They pull it off your websites. And so they pulled this video post off of Santa Fe's website that talked about the company's 5-year plan for promotion and hiring, and that the goals were broken down at every level so that, quote, every hiring manager knows that 1 in 5 hires needs to be a Black employee and 1 in 10 has to be a Latinx employee. Frankly, that's not what they were doing, but that's how they described it. And the description itself was bad enough, and so it gets stuck into a complaint. They also mentioned the diversity policy I mentioned earlier, and ultimately this particular matter was settled. And you can sort of see why. But you'll see this too in the EEOC complaints that get set across. This is one from the Shake Shack complaint. And they were looking at a 5-year diversity target goal of 50% people of color and gender parity by 2025. Again, it was a short time period with a very aggressive goal. The goal itself is not bad. The question was really, how are you going to implement that? And part of that implementation was the use of a diverse slate policy that was noted in the complaint itself. So that's sort of how these things sort of tactically sort of show up. And there's a couple of ways these claims can be brought, right? If you're trying to think about sort of where are the risk factors, you can get charges from the Department of Labor and OFCCP, although OFCCP, in my opinion, will be probably shuttered here in the next week or two. But you can get complaints from the Department of Labor. You can get complaints from the Equal Employment Opportunity Commission. Some of those complaints can be in response to individuals. Elena or I go down the street and we file something. But there's also something called a commissioner's charge that people can bring, that if the commission itself, certain things get brought to its attention, publicly or otherwise, the commission itself can reach out and touch you in a charge, even though an individual complaint has not been filed. And we see some activity in that area. Here's an example of another thing that I'm sure you've heard about. There's been a lot of shareholder litigation of late in this space, typically by activist individuals on both sides of the aisle, frankly, arguing that people should be doing more DE&I or less DE&I. And then they claim that in connection with that, they'll point to something that they allege is misstated, in the proxy statement or in the 10K and try and argue that as a result of that, shareholder value is diminished and therefore give me money. It's all sort of tied to what you say about your DE&I in connection with those public filings. So those are the three sort of primary sources that we see of litigation: private litigation, agency actions in some cases, and shareholder derivative and other suits. What's new? Well, we won't belabor this too much, and you've probably seen this in other alerts we've done. Bill Doyle and I did a whole webinar on this with Ned Childs in our contracting unit a couple of weeks ago. By the way, all that's online on our firm website if you want to sort of pull down those decks and recordings later on. But what's new is that in the past, everything we just talked about has largely been generated by plaintiff action, individual plaintiff action or group plaintiff action, targeting certain initiatives, including things like students at fair admissions, right? That was not an action by the Department of Education, right? That was an action by a group of private plaintiffs. What's changed is now there's an agency focus on this from an administrative federal enforcement side. And we know this because there's a brand new executive order that was issued the other week. It was signed on January 21st and posted the next day. We have links to this and we have other materials that you can take a look at. But it does a couple of different things. For the federal contractors who are on the call, you probably know this already, but it kills Executive Order 11246, which is a federal sort of executive order that deals with minority and women's affirmative action for federal contractors and subcontractors that are covered. It does not kill veterans and disabled affirmative action. You might ask yourself why, because that's by statute and it cannot go away. But were other clauses. It's basically said as a matter of federal enforcement priority, not just for EEOC, not just for DOL, but all agencies. We're going to be focusing on DE&I initiatives that the administration thinks are, quote, unlawful. In addition to that, they're not just going to wait for people to come. They're asking every agency, so not just EEOC, DOL, et cetera, Department of Agriculture, Department of Homeland Security, the Department of Energy, the Department of Defense. Every department is supposed to come up with, frankly, a target list of sectors and particular companies that they think are violating this space and violating these things. And they're supposed to report up their concerns to the Attorney General, who's going to synthesize them, supposedly, in a report in the next 120 days. And then the Attorney General is going to turn that report back over to the agencies for enforcement action. And then in addition to that, they've got brand new flow down language. On one hand, they sort of take burdens away from federal contractors by eliminating Executive Order 11246. Now they've added them back in by adding flow down provisions that supposedly are going to happen in the next few weeks that people are going to start to see showing up in their federal contracts. What do those say? Well, it requires, number one, that if you're a contracting party, you have to agree that you are, quote, in compliance in all respects with all applicable federal anti-discrimination laws. And you have to agree that it's a material element of the contract. A huge obligation, right? Why do they do that? Because they also in the same breath said, and by the way, when you do this, you have to certify that any programs that you have that promote DE&I do not violate applicable federal anti-discrimination law. So they're trying to sort of double trigger it. The problem is it's not just an anti-DE&I clause, it's an any clause, any federal anti-discrimination law. And between you and me, who knows what compliance in all respects with that means. For that reason, it'll probably get enjoined pretty quickly. This happened several years ago. People who may have long memories about this, the Obama administration tried to create something during federal contracting that was called, quote, the blacklisting rule. He didn't call it that. That's what we called it. But basically, it made you certify, compliance with Title VII and the National Labor Relations Act and the Fair Labor Standards Act and a variety of other things. And it was just unduly vague. It's like this. What does compliance mean in all respects? Is it possible to be compliant in all respects? I mean, if I'm a huge company and I have 10,000 employees across the United States and I get 2 EEOC charges in Topeka, am I, quote, out of compliance? Can I not certify compliance? Who knows? That vagueness is part of what got struck down before. And in 2016, that blacklisting rule got enjoined and eventually got dropped by the new administration. That'll probably happen here. But if it doesn't, or pieces of it start to sort of trickle out, it's a big risk, I think, especially for federal contractors who are just trying to do the best they can. The other thing that I would note, again, from an agency standpoint, they've got a new EEOC chair. She is very focused on this. You can look at this quote from her press release. She talks about how in recent years, the agency has remained silent in the face of multiple forms of widespread overt discrimination. Consistent with the president's executive orders, my priorities will include rooting out unlawful DE&I motivated race and sex discrimination. New AG also sort of issued something coming out of the Department of Justice, very similar. And I think that's an overstatement, my goodness. But is it true that, honestly, if I look back over the last 10 years, when people have brought EEOC charges as a group or have tried to bring commissioner charges about DEI initiatives, have they sort of hit a little bit with a thud over at EEOC? Yeah, probably. Right? It's not their highest concern. Hasn't been. Same thing with the Department of Justice. Have people brought these claims before? Yes, they have. Is this been the highest thing on the batting order of DOJ? No, it has not. Will it going forward? I think it will. And they've been very clear that they're changing their enforcement posture on this. So we're not just talking about plaintiff actions, right? We're talking about agency enforcement, the government versus you. So how might that start? Well, again, the past is present, right? We know what the last Trump administration did. Here's an example of something that happened right before the end of the last Trump administration. The OFCCP, again, which I don't think will be around much longer, issued a bunch of, quote, directed reviews targeting corporations, large companies, Fortune 500 companies, who had very aggressive published goals with very short time frames. And they sent letters, demand letters, to all of them saying, this is very interesting to us. Tell us how you're doing it. And by the way, when you're doing that, tell us why you're not violating Title VII in Executive Order 11246. Again, I don't think that'll happen with OFCCP in part because I don't think they'll have much enforcement authority going forward. But do I expect to see this happening with EEOC once the commission has a new quorum of Republicans, probably in around July and August of this year? Yeah, I think you're probably going to see things like this. Likewise, here's a tactic from another group back in the in 2023, the American Alliance for Equal Rights sent out demand letters to every law firm. Boy, this hit home closely, right? Lawyers don't like to be sued, right? The AmLaw 100, we all got across the country, including our firm, demand letters about diversity fellowships and summer internships that we all have. And they sent demand letters to God and everybody, and then they sued too. And they didn't need to sue God and everybody. All they really needed to do is sue two, and who later settled. And then people sort of got the message on that and went back and said, maybe we should go back and take a look at the structure of our programming, not necessarily eliminate the programming, but sort of take a harder look at how the participation requirements are listed, how we describe them, the operational pieces of it to make sure that we're fully compliant. And I think that we'll start to see that too in these kind of things. I think from an agency enforcement standpoint, you might ask yourself, why are they coming up with a target list? This is a target list, right? You have your target list. You make examples out of a couple of them. And the idea is that other people in the same sector, in the same industry, will get the messaging. I think we'll probably see that from the agencies. So do I think that everybody on this call is sort of in the crosshairs? No, I do not. But the higher your profile, the higher your, frankly, brand. Do I think the higher your risk? Yeah. I mean, I think they're going to look for people to make examples of. One other thing before we start to think about sort of other things we're keeping us up at night, there are other executive orders out there, and Lena and I had a good conversation about this. We're talking about, in particular, the executive order I just mentioned, which eliminates affirmative action with respect to minorities or women. It has a new DE&I enforcement focus. But there are, goodness, a plethora of executive orders. Elena and I keep having to hit refresh every other day to see what dropped. This is just one example, right? But this is an executive order focused internally within the government to sort of have different agencies, EEOC included, take a new look at, quote, gender ideology and how sort of people are classified with respect to gender dynamics. You know, we're probably going to see some new guidance on this. Haven't seen it of late, but if you go and look at past guidance, like the enforcement guidance on harassment in the workplace, boy, it's hard to find on the website anymore. They're taking a lot of things down, they're reassessing, and we expect to see new things in the future on that. So that's a little bit of the landscape. I'm going to turn it back over to Elena to talk a little bit about what else are we thinking about.
Well, thanks, Brian. And I'll acknowledge before we go on that there's been some great questions in the Q&A. We'll try to get to some of those in a bit. Also, before I go on, I made an error. There is no QR code. If you gave us your bar number at the beginning when you signed in, you will get a follow-up email after the CLE stuff is settled. So, moving on. I think that Brian's idea with this picture is that with all that's going on and all these crashing together obligations and viewpoints, that cat is the salivating plaintiff's attorney looking at what's going on, just waiting to see what's going to happen. So here we go. So what are the top 3 things that you should be thinking about now? First is, what's about to go out tomorrow, next week, externally, internally, and potentially undertake a privileged review of your affirmative action and DEI communications and programs and practices. I really do encourage you to go and look at, if you haven't seen it already, some of the websites that Brian mentioned before, like America's First Legal, and see what they're doing. As Brian said, all of their complaints are up there, and you can see exactly what, these screenshots they're taking off of public websites and 10Ks and things like that are leading to the complaints. I'm not saying they're right or wrong, but you can see sort of what they're triggering on and think about that for your own organization, which really comes to number 2 as well, right? What gender and race and other materials and programming do you have? What are you advertising about it? Look at your programming and practices to see whether they are exclusive, which is probably a problem, or inclusive. So look back carefully at some of those. And again, 3, these all overlap. What language do you have in what you're publishing in your newsletter, your online posting, your ESG reports? I mean, these things are all out there. And some of it can really be read out of context, because I really believe that employers are not intending to discriminate, and they're trying to do their best by their employees and their customers, their shareholders, and all that. But you can see when you look back at how these issues are being argued now, how some of the things that are being said can be used against the employer. Brian, you want to comment some more on all of that?
Yeah, I think you're exactly right. I mean, going back to the cherry picking thing, they don't spend hours and hours looking for this. Now, they may spend hours and hours thinking about who they want to target and why they want to target. But they're pulling a lot of things off of publicly available sources. In some of those sources, I mean, we represent a lot of clients who have sources who are very carefully drafted and very thoughtful. And we have other sources sometimes that, when it comes to, like, for example, the human capital section of a 10K, it's a cacophony of individuals who sort of weigh in on that language. And sometimes the language is not as exact as you might prefer. And I think that's something definitely, especially given the time of year we're at. We're in the middle of 10K prep season right now. Going back to Elena's good point, you got to think about what's going out the door tomorrow that you need to take a special look at when you're thinking about things like your ESG reports, sustainability, sort of a transparency reports. What sections in there that talk about sort of human capital and DEI, and do you need to sort of take a new hand to that? We're not telling people to misdescribe things, but I think it's a fair question to ask: is do you need to sort of describe things in the same level of detail? And are there ways that you're describing things that, going back to Elena's good point, that aren't exact, that can be clarified? I think that's really important to do. Unfortunately, it has to happen quickly, given the timing that we're in. But we've got some good questions here, Elena. I'll mention one to you to kick it off. Susan had asked a question. She said, did you say that the employment relationship is considered a contract? Is that inconsistent or consistent with employment at will?
Yes, I saw that one. That's a great question. The law is clear that it's a contract, and I don't think they're inconsistent. It's really a contract for employment at will. It's a daily contract. You show up to work. I have told you I will pay you $21 an hour for your hours that day. That's the contract, and all the other things, terms and conditions of employment. But it's clear that Section 1981, which is what prohibits race discrimination in contracts, does apply to the employment context, though not inconsistent with at will. At will is still alive and strong, as much as it ever was. That was a good question, though. Thanks for that one. And Brian, there was one to you. I'm going to say it's to you. Have you heard about contracting officers already putting clauses in contracts and amendments? Clauses you talked about?
That's a great question. And by the way, we have a whole arm of folks here with the McGuireWoods who do nothing but the federal contracting side of the house is led by Ned Childs, and other people on our team are great. And I was talking to Ned earlier this week, and that we haven't started to see that flow down into contracts yet. That's because there's something called the FAR Council, the Federal Acquisition Regulation Council, that has to meet and approve the language that then gets rolled out to agencies. And as of last time we checked, that hadn't happened. But is that on deck to happen pretty soon? I would imagine so. But we have not started to see yet those contract terms. When we do, that's when there'll probably be action to sort of enjoy them. But so far, I haven't seen anything. Now, having said that, you've probably seen something that went out tomorrow that I haven't seen. If you start to see these things that we let Elena and me know, we'd love to see them. See any other questions, Elena?
I'll let you look at some of the later questions. I will. I appreciate one comment made by someone earlier about using the Students for Fair Admissions case in the employment context because they were using race as a factor in decisions. I do think that's a significant part of the problem. I will comment, though, that they were doing so based on Supreme Court precedent that had said that student body diversity was a compelling enough state interest to justify the use of race in university admissions. Now, that case law is no longer good after that decision. So they weren't, they had the support of the Supreme Court on that they were doing it. But yes, I mean, that is why talking about Students for Fair Admissions in the employment contract context really isn't perfect at all.
I think that's a great point, Elena. I mean, for folks who are practitioners in the space on a regular basis, or who aren't HR professionals like a lot of people on this line, they've mixed the law in this area based on sort of education versus employment. And Students for Fair Admissions is always, in the cases that led up to it, as Elena mentioned, there's always a very narrow exception that said race and gender could, in some circumstances, be used as a plus factor. There's a whole balancing test that went along with it, and there are other limitations. But it could, in part, be used in college admissions, not college employment, not college housing, not college scholarships, but college admissions. And that was a very narrow exception. The Supreme Court, even at the time, highly debated it, said it had real strong concerns under equal protection about whether that was a good idea. And actually, in the original cases, said that they were going to look at it again. They actually had a sunset provision. They said that we think this could only last for a certain period of time. It's sort of semi-remedial, and that remedial part will end. But that narrow exception only applied to student admissions, never applied to employment. But unfortunately, a lot of people look back at those cases. These are Google cases about affirmative action, right? And they pull up these education cases. And they go, aha, as long as I'm doing good things in the name of diversity, I can include race and gender as a factor in hiring and promotion and selection, et cetera. That is not the law, has not been the law since 1964. There's some narrow exceptions, and we won't really get into this on this call. There's some cases called Johnson, some others that talk about in some circumstances, in some very limited instances, companies can engage in voluntary affirmative action and in fact use race and gender as a factor in those circumstances. That law, frankly, is very narrow. Frankly, I think that law, if got pushed up to the Supreme Court again, probably wouldn't make it. But it's out there. But the problem is people look at those old education cases and they say, well, that applies to me too. And it's never the case. And I think that's part of the confusion in this space, for better or for worse. But Eleni, did you see any other questions? I know we're about out of time.
Yeah, unless you've got another short one on your end, I think we'll leave it there. We'll reach out to some people on some of the good questions that we didn't get to answer.
Sure.
To Brian's point, Brian, was there anything else you wanted to address on your end?
I think we're right on time.
Okay. So to Brian's point, this thing is an ever-changing landscape right now. Things are coming in all the time. Things have probably happened in the last 57 minutes while we've been talking that impact what we've talked about. We plan to continue this series. We've got a webinar on hot topics in education, higher education, coming up next week. And the week after that is another presentation on DEI programs and peril, how to weigh and mitigate the relative risk. So we invite you to join us for those. As I think I said earlier, but maybe I didn't, feel free to reach out to either one of us. This slide has our information, but you can find us on the web. And we also have our McGuireWoods transitions and a new administration landing page where you can go to find further information about this topic. Well, with that, we thank you all very much for attending and taking an hour out of your day to be with us. And we wish you a great rest of your day.